Well, hello everyone, and welcome to the third Tuesday webinar, Vaccination Policies. Don't get stuck when it comes to compliance. I'm glad that you all could join us today. We have a lot to get through today, so I'm going to try to cover everything we have to cover as thoroughly as I can. We also, if you have questions, you can ask questions in the chat box. You can also always open a ticket after the webinar if you are a myHRcounsel subscriber, or you can send an email at info@myHRcounsel.com. We can give you more information about our subscription packages if you are not already a subscriber. I'm Britt Waterman. I'm a senior attorney at myHRcounsel. And so today we're going to talk a little bit about the history and overview of vaccination. We're going to talk about mandatory vaccination policies, and we're going to talk about providing proof of vaccination. This presentation will be recorded and it will be sent to all attendees. You will also receive a copy of the slide deck to reference along with the recording. Those of you who attend the full presentation will receive 1 hour of HRCI recertification credit. The code for that will be in the follow-up email. You'll also get a sample mandatory vaccination policy template in the email, and again, that's something if you have questions about, you can always ask us about that. We'll also send a survey with that in the email. Please complete the survey and let us know if there are other topics that you would like us to cover. Our ideas for topics for these webinars come from you, from our clients, from people who are interested in learning more about us. So it's really helpful to get an idea from you about what kinds of things you're looking for more information on, and so we appreciate if you return the survey. So let's talk about the COVID-19 vaccine. So December 11th of 2020, the FDA granted emergency use authorization to Pfizer for the Pfizer vaccine, which was the first of the COVID-19 vaccine. And that was an emergency use authorization. You may hear people talking about that. That's a little different than the measles vaccine or the polio vaccine, other vaccines that we've had for years that have had full approval and have been around for many years. So this is the COVID vaccines are under emergency use authorization. 895 million people worldwide are now fully vaccinated. 47.9% of the US population is now fully vaccinated. That percentage varies between city and state. All across the country, the vaccination rate is going to differ widely based on where you are located. And currently there are 3 vaccines available in the United States, 2 more in addition to that Pfizer vaccine for ages 12 and up. So going back to the history of it all, let's talk about Jacobson versus Massachusetts, which is a case that occurred in 1905. A Massachusetts law required all citizens to be vaccinated against smallpox. And one man, Jacobson, who brought the lawsuit, refused to comply with the law. He refused to be vaccinated against smallpox. And as a result of his refusal, he was fined by Massachusetts, by the Commonwealth of Massachusetts. He was fined $5. He appealed this fine all the way up to the Supreme Court, and the US Supreme Court held that the state's police power could be used to protect public health and safety, meaning that the state could enforce laws to protect public health and safety, and that when local boards of health decide that vaccines are needed, the requirement is not unreasonable or arbitrary. And Jacobson is actually still good law, or a law decided back in 1905. This is still the law of the land. This is how school districts can require immunization for school attendance, for example. The Department of Public Health can require vaccinations during certain outbreaks, measles outbreaks, for example. And school districts have the authority under Jacobson to require immunization, but they really have the discretion to make up the requirements that they want. So this is permissive to the states, but states can make it mandatory. So school districts can make up whatever exemptions they want for immunization. Some school districts have no exemption for immunization. Some have philosophical exemptions, which are different than religious exemptions. But this is all referring to the state, to the government, and this does not apply. Jacobson does not involve a private employer, but this applies to a public or government entity. So a history of mandatory vaccine policies. Some of you may have heard that Virginia Mason Hospital in Seattle became the first employer, the first private business to mandate the influenza vaccine. And in 2007, the mandate was actually overturned, not because any government entity found that an employer did not have the authority to mandate a vaccine for their employees, but it was overturned because the hospital failed to bargain with the union. This was employees who were covered by a collective bargaining collective bargaining agreement, and the hospital failed to bargain with the union before issuing the mandate. So kind of overturned on a technicality, but still kind of making inroads into the world of mandatory vaccine policies, and should also be a note for some of you if your employees are subject to a collective bargaining agreement and you're going to make a mandatory vaccine policy or a mandatory anything policy, you need to bargain with the union before you mandate anything of your employees. In 2009, the EEOC issued guidance allowing private employers to mandate vaccine as long as a religious and a medical exemption is, as long as those exemptions are provided to the mandatory policy. The EEOC officially, their official guidance favors encouraging the vaccine over mandating the vaccine. They don't prohibit employers from mandating the vaccine, but they do lean toward encouraging the vaccine rather than mandating it. That's kind of what they prefer to see. But it is legal as long as you leave open that religious and medical exemption. In 2009, OSHA supports mandatory vaccine policies if employers advise of the benefits of the vaccine and allow employees to opt out. OSHA supports an opt-out not just for religion and religious and medical exemptions. OSHA supports or recommends employers allow employees to opt out if an employee has the belief that they have a medical condition that will result in the vaccine causing illness or death. Now the courts, as far as the mandatory vaccine policies being challenged under the ADA or under Title VII of the Civil Rights Act, challenged in court, in order to receive a medical exemption, the employee does have to have a medical condition that meets the definition of disability. Under OSHA, OSHA just requires that an employee has a belief that they are going to be medically harmed by the vaccine. Court cases, Title VII, ADA says it's got to meet the definition of disability. You know, if it's not a disability as defined by the ADA, you do not have to provide an exemption. OSHA makes it a little broader and says, you know, our guidance states that if an employee has a belief that they have a medical condition, even if we don't have proof that they have an ADA defined disability, employers should allow that person to opt out, and that's OSHA guidance, which is different than a federal law. In 2021, and this is very new, you may have heard of this, a federal court dismissed a lawsuit by Houston Methodist Hospital employees who challenged the mandatory vaccine policy. The Houston Methodist decision, the judge's decision dismissing the lawsuit, actually cited Jacobson v. Massachusetts, the case that we just talked about going back to 1905. The Houston Methodist Hospital case was very controversial. The employees challenging the mandatory vaccine policy compared mandating the vaccine to the Holocaust and to other they had very extremist views on that. The federal court said, you know, that's not appropriate, and that mandatory vaccine policies do not even come close. The federal court did not approve of the comparison and was wrote a very strongly worded dismissal of the lawsuit by the Houston Methodist employees. However, the Houston Methodist Hospital employees have already filed an appeal to this lawsuit. So, you know, where will this go? Who will hear this appeal? It will go to the Court of Appeals, and you know who this lands in front of. We'll see. I mean, we'll see how far this goes, and the position of the judges who end up hearing this policy. But this is one to follow, because this could affect mandatory vaccine policies for all employers. About a third of states have mandatory vaccine reporting requirements for healthcare workers. So about a third of states require healthcare workers to report mandatory vaccine policies. Flu vaccines mandates continued. They continued pre-COVID and throughout COVID, although obviously the influenza rate during COVID plummeted because of the protections we were already taking against COVID. In the 2019-2020 flu seasons, in settings where employers mandated the vaccine, 94.4% of healthcare workers did get vaccinated in that case. So just to show, when you're worried about people getting exemptions, people opting out, in healthcare workers where they do offer those exemptions, it is a mandatory vaccine policy. 94.4% of the employees were still vaccinated on average over the US. So let's talk about the exemptions. Title VII of the Civil Rights Act, which is the anti-discrimination in employment law, the federal law that prohibits discrimination in employment that we all follow, and the ADA provide that all mandatory vaccine policies must provide exemptions when an employee's religious beliefs prohibits vaccination, or when an employee's medical condition contraindicates vaccination. When you write your model vaccine or your vaccine policies, and our model vaccination policy that you'll get contains this, the policy should contain a form to request an exemption. It should be very clear that an exemption is available. You should not try to bury this somewhere in the wording of the policy, hoping that no one will request it. It should be very clear that an exemption may be requested. It should contain a form, directions on how to request an exemption. If someone requests an exemption, you can request more information about their spiritual beliefs. You can request documentation from a healthcare provider. You do not have to take them solely at their word. For religious exemptions, employees should be able to tell you what they believe. You can ask for religious texts. You can ask for a note from a spiritual leader. You do not have to accommodate personal or philosophical beliefs that are not associated with a spiritual or religious belief. So someone who believes that vaccines are, too much interference with the government in citizens' lives or something of that nature, or they believe that, that they have a philosophical belief against vaccines, or just prefer not to be vaccinated. You do not have to accommodate that, only when it is truly a religious or a spiritual belief, and you can request some documentation of that. As I stated before, public entities, government agencies do not have to recognize a religious exemption, but private entities do. So if you are a private employer, you do have to allow a religious exemption. As I said before, some states don't have religious exemptions for schools. New York State has a religious exemption for schools, but they suspended it temporarily in 2018 when there was a measles outbreak centered around members of a specific religious group who lived closely together. So, public agencies do go back and forth on allowing a religious exemption, depending on circumstances, but as a private employer, there is no wavering on this. You do have to accommodate an employee's religion under federal law. So reasonable accommodation, someone requests an exemption, you have to provide a reasonable accommodation. So a reasonable accommodation is some type of assistance or changes that will allow the employee with the exemption to perform their job duties or remain employed without receiving the vaccine. Examples would be allowing the unvaccinated employee to wear a mask, moving the employee to a more isolated workspace, someplace where they can guarantee a social distance of at least 6 feet from other employees at all times, working from home, keeping them remote, not calling them back to the office can be a reasonable accommodation for someone who is exempt from accommodation due to religion or medical reasons. You do not have to provide an accommodation if it would be an undue hardship. Undue hardship is a very complicated concept. So for a religious accommodation, undue hardship means more than a de minimis cost. So although there are those right now up to the Supreme Court who feel that this standard should change. But right now, it's if it's going to cause you, a moderate amount of trouble for a religious accommodation, you do not have to provide an accommodation for a religious exemption. Some people, even up to the level of the Supreme Court, think that we should take that up to the level of disability accommodation. So for religion, if it's more than undue hardship, more than moderately difficult, so if it compromises workplace safety, if it requires others to do more hazardous or burdensome work, if it decreases workplace efficiency, if it infringes on the rights of other employees, those could all be examples of undue hardship. And now this is speaking just of religious accommodations, examples of undue hardship for a religious accommodation, which, as I said, has a lower bar than undue hardship for a medical accommodation. Some bars, restaurants, gyms could claim undue hardship with a religious exemption, saying, you know what, allowing the employee to wear a mask or social distance is just not possible here and does not sufficiently protect our customers or clients or guests. And there's no way they can do this work from home. It's an undue hardship to provide the religious exemption. You know, can those types of employers make that argument? Yes, they can make that argument. Is that going to be successful? I don't know. I can't tell you for certain. But I do know with religious accommodation that undue hardship bar is a little lower. For medical exemption for reasonable accommodation, employers must determine whether the worker's presence in the workplace would cause a direct threat due to a substantial risk to health and safety of the individual that cannot be eliminated by a reasonable accommodation. Employers must consider the duration of the risk caused by the employee, the nature and severity of the potential harm caused by the employee's physical presence at the workplace, the likelihood that potential harm could occur, and the imminence of the potential harm. You must consider remote work as an accommodation. You must consider taking job protected leave as an accommodation, so allowing somebody to go on leave if that is the only accommodation you can make. Generally, for a medical accommodation, undue hardship would be a surgical nurse in a cancer unit. Life or death, masks don't protect if they're not worn correctly. A mask isn't as good as a vaccine. They can't social distance from the coworkers of the patient. Reassignment would leave a shortage of highly skilled workers in their department. They can't work from home. Leave may be the only accommodation. So those are the types of employees that would where we would see undue hardship. As opposed to an office, employees can mask, they can move work area, they can social distance, you can reassign their tasks to other workers, they can work from home. You know, a feeling that, you know, well, a mask isn't as effective as the vaccine, and there are breakthrough infections, and we need everybody in attendance all the time, and you know, somebody wearing a mask might take it down to take a drink and cause a breakthrough infection, and then we might have two people absent at the same time. You know, that's not going to be an undue hardship. I mean, with a medical disability exemption, you're really looking at very severe harm in order to reach undue hardship. And that is a very high bar to clear. On-site vaccinations, if you bring a third party onto your site, or if you are a healthcare employer and you're doing on-site vaccination, the pre-screening questions you ask before giving a vaccination are a medical examination. So that is governed by the ADA. The questions you ask: have you ever had an allergic reaction to a vaccine? Those type of questions, that is giving a medical examination. So if you are doing on-site vaccinations and you are mandating vaccinations, you must show a direct threat to the health and safety of the employee or to others to require employees to answer those pre-screening questions. So you must be able to show that if you don't get the employee to answer those pre-screening questions and take that vaccination, it's going to be a direct threat to the health and safety of the employee or others. If the on-site vaccination is voluntary and employees can take it on site or not, and they volunteer to answer the questions, you do not need to show that direct threat. If you do on-site vaccinations, all that pre-screening and vaccine-related information must be kept in a confidential medical file separate from the personnel file. Vaccine incentives. The EEOC says it is legal under the ADA to offer an incentive to those who volunteer proof of vaccination from an outside source. If you, as the employer, are sponsoring the vaccination program, doing on-site vaccinations, or otherwise sponsoring the program, the incentive may not be so substantial as to be coercive. So if you are sponsoring the vaccination program, the EEOC is limiting incentives. Think water bottles or T-shirts, not $50 gift card. If you are sponsoring the vaccination program. A lot of people ask, can we give someone who gets vaccinated extra PTO? Yes, if it's not excessive. Remember tax consequences. Employees must pay taxes on bonuses or gifts that they receive from you as the employer if it's not a de minimis gift, again, like a water bottle or a T-shirt. Don't penalize those who cannot get vaccinated. That is going to cause a problem. I would say, it's okay to offer something extra, a bonus for getting vaccinated and bringing in your proof of vaccination. Don't throw a pizza party or a boat party for people who get vaccinated and make the unvaccinated people sit at their desk and work during it. That's not necessarily illegal. A boat party, maybe. A pizza party, that's probably not illegal. But don't throw a big event and let people who get vaccinated attend and then make your unvaccinated employees sit and work. You might not be breaking the law, but that would be something that would be bad for morale. And one thing that you don't want to do with your vaccine incentive program is to have people who have a disability or a religious exemption. You don't want them to develop hard feelings and start finding fault with your policy start to look at their options and analyze whether your policy is actually compliant. You want your employees to have good morale. You want everybody to be happy and cooperative. So make incentives non-excessive and non-punitive if you can. One note on vaccine incentives, this may differ in your state. So your state law may affect your ability to provide vaccine incentives. I'm going to give an example. Some states have pay equity laws. Oregon is an example. So they require equal pay for comparable work. So if you're making people with disabilities or different religious beliefs miss out on a form of compensation when they are doing the same work, and getting a vaccine is not work, so they are doing the same work as everyone else, that could cause liability. So if you're giving a bonus or something additional compensation to those and people with different religious beliefs or a disability are not getting the same thing, even though everybody's doing the same amount of work, that could cause liability for you under state law. A potential solution would be everybody in the workplace gets a bonus once a certain percentage of the workplace is vaccinated. That would just be an example of how to provide an incentive in a state with a pay equity law like that, where you can't really give additional compensation to an employee who is able to get the vaccine when an employee who is not able to get the vaccine is doing the same amount of work. Again, with the pay equity laws, water bottle, T-shirt, probably not going to matter, but anything more than that, you're going to have a problem. Vaccination status, this is the big one. Can you ask? Yes. Are you required to ask? Maybe. Can you ask why not if they say they are not vaccinated? Definitely not. You cannot ask why not. And when I say are you required to ask, maybe some jurisdictions are requiring employers to document the vaccination status of their employees. Washington State, Oregon, Santa Clara, California are just some of the jurisdictions that are requiring employers to document the vaccination status of their employees. So in those jurisdictions, you would be required to document that. But currently in all jurisdictions, you can ask yes or no, and that is, if you can ask yes or no and leave it at that, that is still allowed everywhere everywhere that you operate within the US. So current CDC guidance when it comes to vaccinated individuals, they can resume normal activities without masks and social distancing. They do not need to wear masks or social distance, either indoors or outdoors. They do not need to quarantine if they have been exposed to a positive case. If they are asymptomatic, if they have symptoms, they do have to quarantine or be tested. They do not need to quarantine before and after travel. They still have to follow all federal, state, and local mandates. So if there is a mask mandate or a limit on indoor gatherings, that does apply to both vaccinated and unvaccinated individuals based on the law in that jurisdiction. The CDC guidance does not trump state and local laws. This current CDC guidance is for non-healthcare workers. So if you are a healthcare industry, there is going to be different guidance that's going to apply to your workers, but this is for non-healthcare workers. You may have heard that the current World Health Organization guidance on fully vaccinated individuals does differ. The CDC is a United States agency. The World Health Organization is, as the name says, a worldwide organization. The World Health Organization is saying that fully vaccinated individuals should keep wearing masks, should keep social distancing. This is for several reasons. It's due to the Delta variant, which is spreading rapidly among unvaccinated populations, and the World Health Organization it includes, or it applies to all countries. So some countries vaccination rates are extremely low, and so the World Health Organization is looking at the world as a whole and saying, you know, we're not ready to let go of these preventative measures, and people should keep wearing masks and keep social distancing. So if you're hearing you know, different guidance and not sure what to believe, that is the difference there. State and local guidance, again, that's going to be different based on your city and state. Currently, no states are requiring travel quarantine for fully vaccinated individuals. So you can travel from state to state if you are fully vaccinated, and you do not have to quarantine in any state if you are vaccinated. 10 states still require people who are not fully vaccinated to mask up in indoor places. And this may change due to, like I said, the Delta variant spreading among the unvaccinated individuals and the number of people who are currently refusing or declining to get vaccinated, which is has been resulting in an increase in positive COVID cases. For example, Los Angeles County did drop their mask mandate, and they are bringing it back, and that is due again to the increase in the spread due to in part to the Delta variant spreading more rapidly among unvaccinated individuals. Current OSHA guidance again differs for workers in a non-healthcare setting. OSHA's position is that if you are in a non-healthcare setting, you can follow the CDC general guidance that I just discussed. OSHA rules establish that employers are still required to create safe working conditions for unvaccinated and at-risk employees. So you do have to consider those employees who are unvaccinated and at risk and keep them safe for if they work with the public. For example, you don't know if you're a public-facing business, if your customers or your vendors, people coming in, are vaccinated or unvaccinated. You need to keep your unvaccinated employees safe, and so make sure that they are allowed to have protective equipment or plexiglass barrier or social distance, whatever measures you're taking. OSHA recommends that employers provide time off to employees to obtain the vaccine, and this is under the American Rescue Plan, which extended the FFCRA, which was mandatory for employers with 500 or fewer employees back in 2020. If it's voluntary in 2021. If you're still providing paid leave for COVID-related reasons and collecting that tax credit, time off to obtain the vaccine would be qualify for paid leave, but this is completely unrelated to that. This is OSHA saying, regardless of whether your employees qualify for paid leave or whether they don't, you should be giving time off to get the vaccine. That's very important. Your state Department of Labor and Industry may have their own guidance, and when there is a conflict between CDC, OSHA, your state Department of Labor and Industry, you should follow the guidance that is the most restrictive, provides the most protection to your employees, and is the safest. So if your local Department of Labor and Industry says, what, we recommend that employees all still wear masks inside, even though the CDC and OSHA says, you don't have to, you should follow your local Department of Labor and Industry, whichever guidance is going to keep your employees the safest. Vaccine status and the ADA. I answered the question, can you ask, with yes. So asking an employee's vaccine status or requesting proof of vaccination is not a prohibited disability-related inquiry. So it is not the same as asking someone if they have a medical condition or a disability. Simply knowing whether someone is or is not vaccinated or viewing proof of vaccination by a third party is not likely to disclose the existence of a disability. Again, I say by a third party because if you are sponsoring the program and requiring on-site vaccinations, and you do ask those pre-screening questions, those may disclose the existence of a disability, so that the other rules under the ADA do apply to that. But if you're asking for proof of vaccination by a third party, hey, bring us in your card from your doctor's office or from the clinic down at the football stadium or wherever, asking for that is not likely to disclose the existence of a disability. Just asking yes or no, people may get vaccinated or not vaccinated for many reasons, and they may or may not be due to a disability. Someone may say, no, I haven't been vaccinated, and that does not disclose the existence of a disability. They may have many reasons for that. As I said, can you ask why not? Absolutely, absolutely not. Once you ask, have you been vaccinated? And they say no, the inquiry stops there. I would, can you ask, do you plan to get the vaccine? I would advise against asking that. Anything that appears like pressure to get the vaccine is something that you want to avoid. So I would say once you ask yes or no and you get a no, I would just leave that no alone. And I would not press after that. I would not say, do you plan to? Are you going to at any point? I would not ask that. So vaccine status and proof of vaccination, as I mentioned, is confidential medical information and must be kept in a confidential medical file apart from the personnel file. Montana actually, and this is kind of an outlier, Montana has a vaccine discrimination law. You cannot require your employee to tell you their status. You cannot require, and this goes back to mandatory vaccine policies applying just to Montana, you cannot require employees to get emergency use vaccines. So as I said in the beginning, the COVID-19 vaccines that we have now are emergency use vaccines. They were authorized under emergency use, which means they have not gone through the process that, as I said, the polio or measles, other vaccines that we do have, and Montana says you cannot require employees to get those emergency use vaccines. If a Montana employee does tell you their status, there are limits on what you can do with that information when you find out. Basically, vaccine status in Montana is just like any other protected class. You can be setting up potential for a vaccine discrimination lawsuit down the road. So in Montana, if you find out vaccine status, I would treat that as the same as knowing someone's race or religion or gender. You just do not want to do anything with that information. You do not want to treat them any differently based on that information. You don't want to do anything with that. Vaccination verification, this is so important. You can obtain the name and the brand and the date of shot only. That is all you can ask for and all you can accept and all you are legally entitled to have. Some vaccine providers are not giving out the CDC cards, and the CDC cards can and are being counterfeited online, which can give you some questions about, well, you know, are the CDC cards the proof we want to accept, in which case you can consider attestation, which is someone signing a document saying, I swear or attest that I have received the vaccine. One of the issues is some people get their shot in a doctor's office and will get a visit summary of the day with their weight, temperature, blood pressure at the time of visit. We had one of our attorneys actually here in the office got the vaccination in a doctor's office, and through the medical information sharing system that shares information through different health systems, she actually got, along with the proof of her COVID vaccine, a printout of her entire immunization history throughout her life. You do not want someone to bring this in. This is all illegal information for you to have. You do not want someone's temperature. You do not want someone's weight. You want the name or the brand of the shot and the date of the shot only. So make sure when you are asking people for proof, you let them know that you do not want to see anything else, any other information other than the name of the shot and the date. So confirmation of it, you can consider maybe confirmation of appointment if they don't have a card. That doesn't necessarily mean that they went through with it. You know, with attestation, you can require them to give the brand of the shot, the date, and the provider of the shot, have them write that all out and sign swearing to that information. If you do attestation, you can notify employees that they will be terminated for a false attestation. So if you do find out that they were not vaccinated and that they signed something swearing that they were, you can terminate them on the spot for false attestation. Attestation is it is a document prepared by your employee, not by a healthcare professional, so it doesn't trigger retention requirements like documents created by a healthcare professional do. Just do not discriminate, be consistent. Don't require more proof from one employee than another because you are suspicious of that employee. I mean, you would have to have really hard evidence that they did not get the vaccination. Don't be more specific of people from a certain race or national origin because you believe they are in a group that is less likely to get vaccinated. Just be consistent. Don't require more of one employee than you would require from another. Pick a method and stick with it. And if you have an extreme situation where an employee doesn't get a card and didn't go to a doctor's office and doesn't have any physical proof, consider the attestation. Confidentiality, like I said, only HR should have access to this confidential medical information. Frontline supervisors may need this to make sure that people are in mask compliance or for business travel. Coworkers should never be told their coworkers' vaccination status for any reason. And ADA regulations do not provide for disclosure to customers, clients, vendors, third parties. Do not do this. This includes staffing agencies disclosing to client companies. This includes you as well. You could be subject to an ADA lawsuit. That includes compensatory and punitive damages, which are capped, and attorney's fees if an employee files an invasion of privacy or disclosure of private facts, tort suit against you. That is uncapped compensatory and punitive damages. So you do not want to share this information. It seems so small and inconsequential, but letting vaccination status out to a third party, whether it's a customer or a client company, if you are a staffing agency or anyone else, and that information gets out of your control and out of your hands, you could be looking at uncapped compensatory and punitive damages. An employee could prove that they were emotionally harmed by the disclosure of their information, and that's just not a situation you want to end up in. As far as, well, what do we do? Our clients want to know. Our customers want to know. You can advertise that we have a policy that we do not let unvaccinated employees go without a mask. That is not the same as disclosing vaccination status, because some vaccinated employees might still wear masks. But you cannot say, if you are, for example, a hair salon, you cannot say, these are our vaccinated stylists. If you want to book with someone vaccinated, pick one of these 5 people. That would be prohibited. If you are a staffing agency and they ask for, your client company asks for vaccination status, you can say you will provide certification that all employees that you send over will either get vaccinated, wear a mask, or both. The employee can voluntarily disclose to the client company if they want to voluntarily disclose, but you cannot tell the client company, we're sending Joe to interview with you and Joe has been vaccinated. That would be prohibited. One other thing, and this has come up a couple times, the Washington Department of Labor and Industry suggested color coding employees' badges to show who is vaccinated and who isn't. Now, this is coming from a state agency, from a Department of Labor and Industry. However, federal law trumps state labor and industry guidance. Do not color code badges. You would be ignoring federal law, and you should always use the law, as we know, that gives the employee the most protection. Color coding badges discloses that status to coworkers. If a vendor is in the building, it discloses the status to the vendor. Any third party who comes in the building and sees the badge knows the status then, and you just can't release that information. Like I said, frontline managers can know the status to make sure people are complying with the mask requirements if they're unvaccinated. Employees can make assumptions about each other based on who is masked and who isn't, but you cannot confirm or deny those assumptions. And vaccine passport bans, a lot of questions about this, a lot of executive orders and legislation and bills introduced, people for and against this, a lot of controversy surrounding vaccine passport bans. 11 states have banned proof of vaccination requirements through executive orders, and 8 states have passed laws banning proof of vaccination requirements. However, no laws or executive order other than Montana's, which we discussed, restricts the rights of a public employer or restricts the rights, excuse me, of a private employer, and that should say private, to require proof of vaccination. So these vaccine passport bans apply to state or government agencies, and I apologize for the misprint there. If you are a private employer in these 19 states, with the exception of Montana, again, Montana is the outlier. Vaccine status is a protected class there, and you cannot require proof of vaccination. But these vaccine passport bans apply primarily to state and government agencies. North Dakota and Florida also apply to patrons or customers. If you are a store or a restaurant, you can't require proof of vaccination to come in and eat at your restaurant or shop at your store. The word patron or customer is right there in the law. Employee is not in the law. In Iowa, if your business requires proof of vaccination, you can't get government contracts or grants, for example. California goes in the opposite direction. They now have a digital vaccine record portal, so you may be able to view an employee's vaccination status on the portal instead of risking employees bringing in the doctor's notes with too much information or keeping a copy of the card and having, the risk of confidential paper lying around. In California, you may be able to just, with the employee's consent, look at the portal. Hawaii, again, opposite direction, using a vaccine passport to travel between the islands. And New York has an app now to show negative COVID tests or proof of vaccination. In Oregon, as I said, businesses need to verify vaccination status to allow anybody, customer, employee, to go without a mask. So in these states that have these vaccine passport bans, unless you are a state or government agency or you get government contracts or grants, do not worry about asking for proof of vaccination from your employees. It does not apply to you unless you are in Montana. If you're in North Dakota and Florida, don't ask for it from your patrons or customers. But other than in Montana, if you're not a state or government agency and you don't get federal grants, don't worry about it. You can still ask for proof of vaccination. That the vaccine passport ban is kind of misunderstood because it does not apply to private employers. So the only other advice I have is that, I mean, these laws and guidelines that I've discussed here today are changing at warp speed. This information in the webinar was compiled as close in time to the presentation as I could get to make sure that I had time to proof the deck and go through my notes for each slide to make sure I didn't miss any talking points. Your state may have changed something over the weekend. If I say something, if there was something that we covered in the webinar and you think, I just heard something new, or you just want to be sure before you take action, please open a ticket and ask for clarification. Run your suspicions or your questions by us. Our attorneys can research up-to-the-minute laws and guidance in response to any specific question. We do try to keep clients updated in our newsletter, but with all 50 states plus various cities around the corner, it can be like trying to drink from a fire hose, trying to report every change in every jurisdiction every time it happens. So the best advice that I can give you is, to keep your eyes and ears open, and when you have questions, please reach out to us. Please open a ticket and just ask us, hey, has this changed, or what can you tell us about this, or are we still doing this? Are we doing the right thing? Please just ask us. If you are not yet a subscriber to myHRcounsel, please visit myHRcounsel.com to learn more about our subscription and the options available to you, and how we can help you comply with all vaccine-related guidance and legislation. You can also contact us at info@myHRcounsel.com to get more information about our subscription. Our subscription services are great. You have licensed attorneys who can answer any of your HR and employment law questions, not just COVID or vaccine related, but related to any HR and employment law topic. We can answer them on demand, and we can provide you with policy templates like the one included today, other employment law documents, things like that that are very valuable, and that information is available at myHRcounsel.com.
Thank you, Britt. Before we end, we have a few questions from our attendees that I wanted to get to.
Okay.
The first one here is, as a staffing agency, can we let our clients know that a candidate's vaccination status if the candidate has given us permission?
Yes, if the client volunteers that information, I would get that in writing. I would have your employee put something in writing that they are consenting to the disclosure of their vaccination status to this particular client. I would limit the disclosure to one particular client, and each time you send them to interview with a new client or send them on a new assignment, I would again have them sign a consent to disclose their status. But yes, you can if the employee gives you permission to share that, but again, get consent and get it in writing.
Awesome. And then can you please repeat which states and cities are requiring employers to track vaccinations?
Yes, so right now, and this, again, this is one of those things that could change, that states and cities are adding all the time. Currently, Washington State, Oregon, and Santa Clara, California are the only jurisdictions that are requiring employers to document the vaccination status of all their employees. Again, subject to change, and like I said, keep your eyes and ears open within professional organizations in your community, watching the news, anything you can do, just checking back with us and asking. Those are the only jurisdictions that I am aware of now, but it is always subject to change.
Awesome. And then just two more. The next one, can you ask customers if they are vaccinated if they are in a healthcare facility?
Can you ask patients if they're vaccinated, or I guess I'm not sure. If you are a healthcare facility and someone is seeking medical attention from a healthcare facility, you can certainly ask if that person is vaccinated. If it is, I guess if you're a healthcare facility, I guess I don't know what other type of customer. I guess if you're a home health agency and you have a client, yes, you can ask that person if they are vaccinated.
And then I believe this one is referring to requiring vaccinations, but the question is, what if the company is privately owned but contracts work with the government?
Again, that is not a problem except in Montana. The only, as far as mandatory vaccine policies, that is allowed anywhere, although if you contract with the government in Montana, I would not do that there. If you contract with the government, with the federal government or the government in any other state, yes, you can have a mandatory vaccine policy. The laws, the vaccine passport bans do not relate to employment. What they relate to is state and government agencies or people who businesses who contract with state and government agencies can't require people to show a vaccine, proof of vaccine to get services. So for example, if you are a construction company and you contract with the government, you cannot require someone to show proof of vaccination. Not an employee, but you can't require someone to in order to receive your construction services. So those vaccine passport bans are, if you are the Department of Human Services and someone wants to apply for public assistance, you cannot require proof of vaccination. That's what those vaccine passports are. So as far as mandatory vaccine policies, even if you contract with a state or federal agency, you can implement a mandatory vaccine policy. However, Montana does not allow you to mandate those emergency authorization use vaccines. So in Montana, you cannot do that.
And then we just had a follow-up on the medical facility, and the question is, if you are a dental clinic, can you ask a customer if they are vaccinated?
Yes.
All right. Thank you, Britt.
Great. Thanks, everyone.
Just as a reminder, everyone, we will be sending out an email on Thursday. This email will include a recording of the webinar. You'll also have a copy of the slide deck, the HRCI code for recertification, as well as that policy template. So be on the lookout for that. It'll probably come about Thursday afternoon around 2 p.m. Central. And thank you everyone for attending.